Good afternoon, everybody. I have that it's about 1 minute after 12. So I am going to get started, assuming that we'll have some stragglers join us. Perhaps they're going to get our lunch. James, can you just do me a favor and check to see whether or not you can participate, because I don't have you muted at the moment?
I am here.
Wonderful. I'd like to introduce my partner, James Cousins. My name is Melissa Day, and this is the second COVID-19 webinar that we've presented with a particular focus on how the pandemic and the disease impacts workers' compensation claims in New York. And if you would like to get access to the original presentation, which is still pertinent, just give us email us or contact us after the presentation. We'd be glad to provide you with the access to that. So I have a lot to talk about today, and I just need to make sure that my presenter view is on. Great. All right, so there are three broad topics that I want to cover today. The first is reopening. The second is the impact on compensability, how the reopening is going to impact compensability of COVID-19 claims, and the Workers' Compensation Board's response. Please bear with me for a second while I adjust my partner's audio settings. I believe he is now unmuted. James?
I am back. Yes, I am.
Be still my heart. Okay, so three topics we're going to cover today. The reopening, which is started as of today of New York, that impact on compensability of COVID-19 claims, and the Workers' Compensation Board's ongoing response to the epidemic. As of today, there are, depending upon the source of your statistics, nearly 1.5 million cases in the United States and nearly 87,000 deaths. Additionally, over 300,000 people are designated as recovered from the disease. I'd just like to note that as of the date that I did my last presentation, which was March 27th, at that time, according to the CDC, there were about 15,000, a little bit more than 15,000 confirmed cases of COVID-19 in the United States. So as of today, we have approximately 100 times more cases today. In New York, we have we're approaching 350,000 positive COVID cases. And because when we reopen is dependent on the rates of testing, hospitalization, and the number of positive results, among other data, I would recommend that you visit the state's websites with respect to the data that's being compiled about the epidemic, the rates of positive tests, the rates of recovered people, the open hospital beds, et cetera, because all that is pertinent to when certain locations in the state are reopening. I'm just going to take you there for a second because I would like to show you the features that are available as part of this website that the state has. So you can see here that you can select any county within the state. So I'm going to select Erie County, and you can get the statistics related to that county. You can also look at the county by table view and there's daily trends, there's fatality data, etc. And it also allows you to check on the time period that you're interested in looking at. And all that is relevant, and as we're going to discuss, and when a region can reopen. Just interesting to note too, that the state has conducted antibody tests to take a look to see how many people have antibodies for the disease in an effort to try and glean some information about exposure and contraction of the disease for people who haven't become sick. And those rates have vacillated between, I would say, approximately 13 to 15%, and of course it varies differently, wildly differently, depending upon where you live in New York, with New York City approaching approximately 20% of the population as having antibodies, which means that approximately 1 in 5 people has been exposed to and contracted the disease, and now has evidence of that contracture. So that's, I think that adds some color and some additional information to the pervasiveness and the effect of this disease on our community. At the time of our last presentation, I put together a timeline up until at that point, and this is a very fast-moving issue. There's dramatic changes every week. As you can see from the time between when I gave my first presentation in March to today, there are 100 times more cases. And we concluded I concluded the timeline for my presentation at the last presentation with a projection as to what April 1st might bring us. And at that time, there was pending as part of the budget bill, which in New York is the deadline for passing the budget is April 1st. So we frequently end up with a lot of legislation getting passed as of April 1st. We believed that in connection with the budget bill, there may be a statute which would get passed regarding a presumption of compensability for certain workers for COVID-19. And those would be the people you might expect, which would be emergency room workers, frontline, first responders, healthcare workers, etc. That bill did not pass as part of the budget. It wasn't included in the budget. However, it is still pending, and we're going to talk about that a little later. One thing that I think is pertinent to us as stakeholders in the workers' compensation system in New York is that the state did pass mandatory sick leave for all employers. Well, let me put it this way. Mandatory sick leave for employers of a certain size and job protection for sick leave for all employers. So if you are an employer with between 5 to 99 employees, you have to give 5 days of paid sick leave. If you're over 99, then you have to give at least 7. And if you're under 5 employees, then you do have to protect a worker. You have to protect a worker's job for 5 sick days. Continuing on with our timeline since we last met, I've put together some highlights for New York. This is specific to New York. In the beginning of April, Governor Cuomo extended our pause order, which is the name that was given to the cessation of non-essential business. In the beginning of April, it was extended to April 29th, and of course, we've had another pause order continued since then. We've had a couple of orders from the governor directing that people wear face masks in certain situations. One of them being that employers are required to, essential employers are required to provide their employees with protective face coverings. And there's also, excuse me, an order by the governor requiring people to wear face coverings in public where safe social distancing cannot be met. So that was primarily, I believe, for people who were continuing to ride the public transit systems in New York, but it is a requirement that you wear face coverings in the public, and as more businesses open, this is going to become more and more, I think, relevant to the general public as we start to get back into our regular, well, quasi-regular activities. On April 16th, the pause order was extended until May 15th, which is today. And we're going to talk about some of the changes that are going into effect today for some regions in New York. On April 16th, the governor's order or plan for blueprint for unpausing was first released, and it's become more detailed, and it's become incredibly detailed actually, since that original blueprint was issued in April and on April 16th of 20. On April 21st of 2020, and this is a big deal for us, obviously, elective outpatient treatments could resume in certain counties in the state and hospitals without a significant risk of COVID-19 contraction. So for most of us, all elective surgical procedures, which is what most workers' compensation procedures are characterized as, have not been performed for the past 10 weeks. I forget what week we're on. 8 or 9 or 10 weeks. But as of April 21st, the order came out, and a couple of days later, certain areas in the state were allowed to resume elective surgical procedures. And since that time, there have been additional counties that have been added to that list. On April 21st and 22nd, New York State took steps in conjunction with the federal government and then with New York City to both double our testing capacity with an eye toward eventually being able to reopen, because testing is believed to be very critically important to being able to safely reopen, as well as contact tracing, which is being able to identify what people, somebody who contracts the disease has been exposed to during a time when the person might have been contagious, so that those people can then be quarantined to limit the spread of the disease. On April 25th, Governor Cuomo announced a plan to test all first responders, healthcare workers, and essential employees. And I think that's relevant to our insured's potential exposure for COVID-19 workers' comp claims. In other words, if our insureds are healthcare facilities or they're first responders in some capacity or an essential business and they don't test their workers and then somebody contracts the disease, I think that it's going to be relatively easier for that individual to be able to demonstrate that the contracture was in the course of employment. On April 26th of 20, the governor announced the phased plan to reopen, which is 4 phases, and we started phase 1 in certain regions today. As of April 28th of 20, additional guidelines to reopen were announced. Additional counties and hospitals were allowed to go forward with elective surgeries as of April 29th, and as of 5/4, the governor issued additional guidelines, as I said, has become more and more detailed as to when regions can reopen. And so now we're going to get into the meat of where we are right now. As of 5/11/20, which was just the beginning of this week, the governor announced that 3 regions were prepared to open based on 7 criteria that have been set in order for a region to reopen. By, I think it was yesterday, there were 5 regions that were ready to reopen. As of Monday, the governor also allowed low-risk business and recreational activities to resume. So I don't know if everybody knows about this. So for example, landscaping and gardening, that type of thing. Tennis and drive-in movie theaters are allowed to open as of today statewide. So I don't know if many of you have been to a drive-in lately, but I have a feeling that drive-ins, which had been really on their way out in this country, they hadn't been able to really maintain profitability, many of them, because it's really a concession issue where people, because the food sales are what really drives the profitability of most theaters, whether they're drive-in or sit-down. But I have a feeling now that we're going to see a resurgence in the popularity of drive-ins because I don't do much fun things on the weekends, but I do like to go to movies. So I can imagine that there's going to be a very high demand for people who want to go to the drive-ins with their families. I would like to discuss in a little bit more detail the New York Forward Reopening Plan that the governor published on May 11th. So we're just going to go and follow that for a second. You can see there's a very detailed 51-page booklet that New York has promulgated as part of the reopening plan. It's incredibly detailed with this is not going to be a resource for you, I don't think, like some of the other resources that New York has published in connection with the reopening. But this will give you a background and criteria for what the state is focused on in order to make the reopening as safe as possible and to avoid a slide back to where we were in the middle of March and in the beginning of April. On 5/11 of 20, the state announced a regional monitoring dashboard. So if you remember, I mentioned that 5 regions in New York State are allowed to open today or enter phase 1 of the reopening because they've met 7 criteria that the state has set in order to be able to reopen. So you can see here, and this is another great resource. So if you're in a region that hasn't reopened yet, and in fact, Erie County, or Western New York, where we are, yesterday had met 5 out of 7 of the benchmarks. And we've slid back, unfortunately, today and only meet 4 out of 7 of the benchmarks. So we're not going in the right direction, unfortunately. But you can see here, these are the criteria that the state is requiring in order for a region to be open. These are our regions, the Western New York, the Finger Lakes, Central New York, et cetera. And this will provide you with an indication as to which of the criteria that your region has met toward being able to reopen. What hasn't really been clear or discussed by the state is what happens when a region slides back, because I can certainly envision that a region might be able to commence in phase 1 and then would, just like we did here in Western New York, we met 5 of the 7 criteria yesterday. As of today, we only meet 4 of the 7 criteria. And so if a region does fall back and the criteria that have been required in order for them to move forward into phase 1, are they going to stall in a phase, or are they actually going to be shut down again, which I think will be very unpopular. So I recommend these resources. If anybody is interested in a copy of the presentation after today, I'd be happy to provide you with a PowerPoint or a PDF of it with the links in it so that you can go to some of these resources. Oops. As of today's Friday, as of Wednesday, 2 more counties met 12 more counties now became eligible to resume elective surgeries. I don't believe Erie County is on that list yet, but many of the other counties where a lot of you have workers' compensation claims are now on the list. We're up to a total of, I think, 47 out of our 62 counties now permit elective surgeries to go forward, and that includes places like Albany County. We are certainly opening up for medical procedures to get back to where we had been prior to the pandemic. Yesterday, the 2 more regions hit the benchmarks that they needed to hit in order to reopen and go into phase 1. And as of today, those 5 regions are permitted to reopen and are in phase 1 of the reopening. We're going to talk about that a little bit more in depth. Okay. So the plan for reopening is to, as I mentioned earlier, is to reopen in 4 phases. The first phase is focused on reopening more essential businesses where it is believed that the risk of infection is lower than in other industries. And phase 1 includes construction, manufacturing, and retail, which are many of the types of employers where we see workers' compensation claims. Of course, essential businesses like hospitals, nursing homes, that sort of thing, they've continued to be open. Phase 2 would include businesses like mine and like many of yours. It's professional services, which includes insurance, which is what we fall under. I have to say that insurance and financial services, which is what many of you would fall under, are also considered essential services. And as a result, many of us have been allowed to continue working and could have had our offices open. But another requirement was that if we could maintain social distancing by allowing our employees to work from home, that was required. So for example, in our office here, we have 25 employees. Only myself and another individual come to the office every day. And the only reason I have 2 people come to the office is because I have 2 separate suites. And so I can come to this suite and not be exposed to anybody else during the day. And my other staff member can go to my other suite. But we will be in phase 2 of the reopening. That will include all other retail establishments beyond retail or curbside pickup, which is allowed in phase 1. Phase 3, of course, are places where we can imagine that the risk of infection would be greater. Certainly more difficult to maintain social distancing. And if anybody of you saw on the news yesterday, there was one of the news channels did an experiment where they showed the contact of how germs from people's faces and hands can spread at a dinner table. It was really something else to really show you how you may think that you're being very careful about spreading your germs, but it's a lot easier to do than you might think it is. So phase 3 will be restaurants and food services, and then phase 4 will be arts and entertainment, recreation, concerts, sporting events, education, etc. So we are, as I said, in phase 1 in certain regions in the state, not all regions. Okay, I'd just like to, so I mentioned that the recommendations from New York are getting more and more detailed as we get further and further along in the process. And I'd just like to share with you some of the requirements that the state is issuing and guidance that it's issuing in phase 1 where we are right now. Guidance for phases 2, 3, and 4 has not been issued yet, and I would think that the state is going to be responding to how well this guidance works with manufacturing, construction, retail, etc. Right. So each of these different types of employers, construction, manufacturing, etc., has instructions that have been laid out by the state in order to safely reopen. And they're incredibly detailed and pretty strict. This is a summary for construction, what is expected. Right. So, I mean, there's mandatory guidance in addition to recommended best practices. And each of these, I've looked at the guidance for each one of these different types of employers that are allowed to open in phase 1. They each address both physical distancing, protective equipment, cleaning and hygiene, as well as communication with the employees. Right? And this is the summary. So this isn't even the detailed guidelines that are that have been published for each one of these types of employers. And I think that this is very relevant to us in litigating COVID-19 claims at the Workers' Compensation Board, because if an employer doesn't follow these requirements and doesn't follow the guidelines that have been issued and doesn't have a safety plan, which is also required, then I believe it will be a lot easier for a worker who contracts COVID-19 to make an argument that they've contracted the condition in the course of their employment. So for those of you who have relationships with your insureds, that really puts you in an advisory kind of position. If you're a carrier and you want to work to minimize your exposure, then you're going to want to ensure that your insureds are following these guidelines, these very specific guidelines that have been issued by the state for protecting employees and customers and in other areas of risk, the general public, from contracting the disease in connection with your business operations. The business safety template that I was referencing, this is another requirement for when a business reopens. And from what I can see with this business, the safety plan. So a lot of you, I'm sure, are familiar with safety plans and other components for your insureds. This safety plan is very general so it strikes me that this is something that each business in New York State that reopens, including mine, including yours, and including all your insureds, should create and implement as part of the reopening of their business. And so you can see that we're going to discuss this a little bit more in depth, but it addresses people, places, and processes for your employment. And then lastly, there's a business affirmation that is required as part of a reopening, which makes a business have to state, and this is, again, we're still limited to phase 1 because those are the only businesses that are reopening, other than businesses that are essential that have already been open. It's going to require you to essentially keep an affirmation as an employer stating that you've created a business plan or a business safety plan, and that you also are following the both summary guideline and very detailed guidelines for your particular industry. The safety plan template that I just referenced, as I said, it addresses people, places, and processes. And to give you a sense of what an employer, all employers, including where you work and the employers where your injured workers work. For people, there are requirements for physical distancing, as you might imagine. The distance is 6 feet between personnel. There's a limit on tightly confined spaces as to how many people you can have. You're to mark out physical space to make sure that you're providing guidance to people as to how to maintain a safe distance. You're supposed to limit gatherings where multiple people will attend, establish designated areas for deliveries or interaction with the public, and then also allow for remote working if that's one of the solutions that your industry or your business can come up with, as an alternative to keeping people who might be more susceptible or have comorbidities to the disease, to allow them to continue to work safely. There are in these business plans requirements with respect to the places where people work, not only the provision of protective equipment, but also you need to come up with a plan for hygiene and how your physical space will be cleaned. Additionally, the business safety plan requires employers to come up with a way to communicate with all its employees and to post that information, just like we're required now to post certain information that pertain to workers' rights, regarding PPE, regarding the procedures for safe interaction with customers. You have to keep logs of people who contract the disease, and take certain steps with respect to notification of public health officials when somebody does, so that contact tracing, there's an emphasis on in connection with the 7 criteria reopening from New York State, so that can take place. And then lastly, the business plan requires employers to come up with a process for screening its employees to make sure that they are to help identify people who may be sick, and then also to disinfect contaminated areas, so that when you do have somebody who comes down with the sickness, there are procedures that you will have to identify as part of your safety plan for being able to disinfect and clean the area where the injured or where the sick individual was. So it's going to be hard. I mean, it's definitely like reopening isn't just like bringing everybody back. I mean, and of course, I think that nobody had an expectation that it was going to be just bring everybody back to the office. But what will really be required in order to keep people safe? And these are requirements that I think are really targeted at helping us to stay open. So as draconian as they may seem, I also believe that they're very important for us to be able to get back to functioning as an economy again. Okay, so why is all this information on reopening important, other than, of course, it affects each and every one of us with how we will be working in the near future. How it relates to workers' compensation is, I've already alluded to that. We have certainly known that and talked about, and you've probably received a ton of white papers from various law firms and consulting groups, that we know that COVID-19 could be compensable under certain circumstances, where if it's an occupational disease, the person would be able to develop facts that show that a distinctive feature of their employment brings them into contact with people who could be infected. That you can easily imagine nurses, EMTs, corrections officers, police officers, and the like, so that they could meet the criteria for demonstrating a causal relationship between their condition and their employment, as well as show that a distinctive feature of their employment caused them to contract the disease. So that's occupational diseases specifically. With respect to accidents, again, if you have a known case of COVID-19 that required, and your employee was required to be in contact with that person as a part of their job duties or in the course of their employment, I think it would not be, it's certainly, you can envision how such a claim could be established as an accidental claim, even though a distinctive feature of the individual's employment may not be such that you would expect them to come into contact with people who have contracted the disease. So a healthcare worker, a distinctive feature of their employment would definitely bring them into contact with people who might be infected. Somebody who works in a law office like mine, where you don't really have tons of clients coming in, you wouldn't really think that a distinctive feature of their employment would bring them into contact on a regular basis with people who had contract or who had the disease. However, if the FedEx guy comes to the door and that person has to interact with the FedEx guy, and he's coughing and sneezing, and then ultimately we discover that he has been diagnosed with COVID-19, an individual in a situation, an office like mine, could likely be able to prove that they contracted that disease in the course of their employment and get it established as an accident. We have received kind of writing on the wall from our chairperson, Clarissa Rodriguez, who authored a letter to all workers' comp payers regarding COVID-19 and how individuals who contract the disease should be treated, even if there's a very strong argument that the individual did not contract the disease in the course and scope of their employment. And so the board is encouraging workers' comp payers to provide those claim forms to people. They're reminding us that it's illegal to take adverse employment action against an employee who is thinking about filing a workers' compensation claim under Section 120. The chair is encouraging employers and payers to assist people who have developed the disease in filing claims, conducting investigations as quickly as possible, to pay without prejudice, which we know we can do under Section 21A, when possible, rather than disputing a claim. And then if a decision is made to controvert the claim, the board is telling us that they will be following their rocket docket procedures in order to litigate those issues. That, to me, is a little bit of an empty threat, because the board has also issued inconsistent guidance with respect to obtaining IMEs in controverted claims. And we know from our experience in handling hearings at the board that extensions are being liberally given. So I'm not quite sure that Chair Rodriguez's insistence that the rocket docket would be followed is necessarily true in practice, although I'm sure she would like it to be in theory. So as I mentioned earlier, my concern with these very specific, the guidance that is being issued by multiple different, I mean, not just New York State. I mean, there are many consultants and economic development agencies and counties and municipalities that are issuing guidance with respect to what an employer should do in order to safely reopen. And we all understand that that claims that are litigated at the Workers' Compensation Board, as is frequently cited in board panel decisions and at the appellate division, that because the workers' compensation law is meant to achieve its humanitarian objectives, and I'm really kind of loosely paraphrasing right now, we know that the presumption of compensability is generally given to the claimant, even in situations where the burden actually rests on the claimant and not the employer to demonstrate causal connection between one feature and another. And so my belief is that if an employer doesn't follow the guidance that the state is requiring to reopen, and an individual contracts COVID-19, and that employer cannot demonstrate that they followed what the state says is the safe procedures for reopening, or they don't have a business plan, or they don't have the affirmation saying that they've complied with the requirements for each specific industry, then the board may take that information and may turn it into a presumption that the injured worker contracted that condition at the employer. So I would say, that we should beware, and we should also be looking to our insureds and our employers and giving advice that when they're reopening, that not only is this what's required by the state in order to keep employees safe, it also may be beneficial to our insureds and clients in defending them from workers' compensation claims. As I mentioned, there is still pending, even though it didn't pass as part of the budget bill, there is still pending this bill to create a presumption of compensability for frontline workers, for first responders, for healthcare workers, for any business essentially that's deemed as being essential by the governor's executive orders. I really don't feel that this legislation is necessary. I mean, in conjunction with what we've just reviewed for what's required in order to safely reopen for other kinds of businesses, I think that it would be pretty, I mean, the political winds are in the air where, it's certainly going to be favored to assist our frontline workers in obtaining whatever benefits they could use in order to be able to weather a storm created by their contraction of COVID-19. And certainly for most claims that might come across our desks, the costs associated, well, the hospitalization could actually be quite expensive, depending upon what treatment the person would require. Many of these claims would simply be quarantine claims or claims where the person was able to recover at home. But you can also envision that there could be death claims. And certainly those kinds of claims must already exist, or they're about to exist, because we know of many frontline workers who have lost their lives in performing their job activities. Okay, so the last thing I wanted to talk about with respect to compensability of COVID-19 claims is the idea of consequential COVID-19 claims. This occurred to me as I was preparing the materials, and as frequently happens, I think, when somebody is putting together materials for a webinar, for a presentation, your mind starts to go off on all the tangents that could be possible when you're looking at a situation and wanting to present information about it. And some of the things that came to mind while I was doing this, especially when I was thinking about elective surgeries occurring again, and doctor's offices. I myself have had 2 in-person doctor's visits within the past couple of weeks. And so I believe that we're going to see people start to get back into their doctor's offices with more frequency. And in connection with those 2 changes and transitions back to quasi-normal life, it occurred to me that with elective surgeries and in-person evaluations, whether they be with an attending physician or with an IME, that it's certainly feasible that an individual could contract COVID-19 because of their exposure to somebody who has the condition at a hospital or an outpatient center, or at a physician's office, or at an IME office. And so then the question arose in my mind, like, would we be responsible for the individual's contracture of the COVID-19 in connection with a back claim where there was an elective surgery that went forward and the individual ultimately contracted the disease? Would we be responsible if an individual contracts COVID-19 because they go to their own physician's office and it's discovered that an LPN who took their blood pressure had the disease, and ultimately our claimant developed COVID-19 as a result of that? And if the answer to that is yes, and I certainly think that any one of us who has dealt with a consequential claim where every body part got established on something that started off as a minor toe injury, then the question arises is whether or not could you maintain a third-party action against the potentially negligent third party not in the same employ. And then could you reach out to that entity, the hospital, the doctor's office, the IME company, and demand to see their business plan and their affirmation that they're complying with the guidelines that the state has issued with respect to their industry? And if so, I think we're still going to be liable for the person's recovery from the condition if it leads to an inability to work, or in the most unfortunate circumstances where somebody dies as a result, would we then be able to sue another person not in the same employee for their negligence in causing the additional compensation that would be due as a result of the contracture? I would have to say yes, possibly to all of these things.
It's like a very extreme, nebulous version of the slip and fall on the icy parking lot on the way to physical therapy. I remember when I first encountered that practicing workers' compensation law and was just shocked that premises liability is just shoved into the comp case right away. And it's very rare that subrogation actions, from my understanding, are taken in those circumstances. But I mean, wow. And this would be hard to prove where they got it, though, too, right?
Well, I think if I mean, it's the same. Like I said, like if they don't have, if the business hasn't implemented fully those safety procedures that the state, I mean, you saw the list of things that you're required to do.
Yeah.
If the state hasn't implemented those procedures, or the business hasn't implemented those procedures, then isn't it presumptive that they didn't keep their employees or the people who are interacting with their employees as safe as they could have? I mean, aren't all employers now on notice that if you don't follow these safety procedures, then perhaps you might be exposed to some sort of additional liability as a result?
It would be nice. I would tend to agree with that, but I would hope that they would have said at the same time, if you follow this stuff, you're safe. But we know that they won't do that as an employer. Yeah, you can't think that way in the state of New York. Yeah, if they were less like guidelines and more like, okay, these are your acting temporary regulations for reopening your businesses, and you're covered if you can prove you did all this stuff. That would be one thing. But, and I guess I also asked the next question. We don't have to discuss it, but how natural is it? Are we just going to presume that it's it's direct? Sure. Is it natural? I don't know. Direct and natural consequence,
Well, certainly malpractice actions have led to subrogation actions for when a physician commits malpractice on a workers' compensation claim, and it doesn't relieve the employer or payer of the complications related to the malpractice, but it does give the employer or payer an action against the physician. I think it'd be a heck of a lot easier to potentially prove negligence of a healthcare facility or of a doctor's office with respect to whether or not they've taken all the steps that they could have taken in order to protect somebody from getting the disease than it would be to prove malpractice, which is a very high bar.
Right.
So I would say keep your eyes out for those types of situations and protect your insureds and yourselves from those situations. Okay, so I've sort of wrapped up the topic of talking about compensability of COVID-19, and I'd like to transition now into our third topic, which is the action that the Workers' Comp Board has taken. And I just want to remind everybody of what the board, the steps that the board had taken at the time I did my presentation in March on March 27th. The board went to all virtual hearings. They discussed the 90-day requirement for medical evidence. The board did not relieve an injured worker of having to produce medical evidence every 90 days. It just said that it was going to be very forgiving if an individual was unable to meet the 90-day requirement. However, it's still a requirement that an individual produce medical evidence every 90 days. So if you have workers who haven't produced medical evidence of an ongoing disability and there's no evidence of permanency and it's prior to classification, then certainly feel free to file an RFA to suspend, because there's no presumption of ongoing disability even during a pandemic. And that is especially true because the board promulgated an emergency regulation allowing telemedicine. And we have seen many evaluations by physicians using telemedicine. The failure to attend an IME, as you may know, in pre-pandemic, in the before times is how I like to refer to it. In the before times, the failure to attend an IME could lead to a suspension of indemnity benefits and to a carrier not having to pay for medical treatment if the injured worker failed to attend an IME after probably being given several chances to attend an IME by a judge. But regardless, they were required to attend an IME. In today's times, obviously, it's whether or not a claimant refuses to, whether or not it would be considered reasonable. And certainly during today and the situation that we have right now, I think we can all envision how a board or a judge might find that it's reasonable for a claimant to refuse to attend an IME. Give me 1 minute here. I just want to make sure that I have everybody muted because I did hear some typing and it can be distracting. Okay, looks good. The board also discussed the C4 auth 30-day requirement and did not relieve us of that obligation and noted instead that carriers and payers can obtain a record review if there's an issue about whether or not treatment is reasonable. Please recall that a C4 auth only addresses the reasonableness of treatment. And so if you have a defense of causal relationship, but you don't really have a defense about whether the treatment is appropriate under the guidelines, you can maintain your defense on causal relationship and still allow the procedure to go forward. You can just mark that right on the C4 auth. And also, conversely, if the board goes ahead and authorizes treatment because you didn't timely respond to a C4 auth, that only addresses the reasonableness of the treatment, not whether or not it's causally related to your injury. For workers' comp board directed IMEs and situations where a claim is controverted, I alluded to this a little bit earlier with the chair, and in cases where permanency evidence has been issued, generally the board would issue either the regulations either require that you have an IME within 3 days of the first expedited hearing in a rocket docket controverted claim, or the board will issue an EC 81.7 or a proposed decision requiring that the parties produce evidence of permanency within a certain time. And the board has been very liberal about granting extensions of time for carriers and employers to get those IMEs. In fact, I have a controverted claim. I was given 90 days for my client to get an IME. So rocket docket or not, the board is being very liberal in granting extensions. The same is true with depositions as well as appeals and rebuttals. We're getting extensions of time to conduct depositions fairly liberally, and appeals and rebuttals, as we'll see in a minute when we take a look at some board panel decisions. The board has been indicated that it will allow, excuse me, I didn't mean to fast forward that, will allow a party to provide an explanation as to difficulties they may have faced with timely filing an appeal or a rebuttal because of COVID-19. The same was true with respect to the time to respond to penalties. Both penalties issued as a result of failure to comply with Section 50, as well as the first report of injury penalties. The board issued emergency relief from having to produce original signatures in connection with certain documents. And then lastly, and we're going to talk about this a little bit more in depth, the board also relieved claimants of having to produce labor market attachment proofs and suspended that requirement in litigation at the board.
I call that the napkin rule.
Yeah, why?
It has the same legal authority as a napkin.
Like that?
Yeah, one that has some jelly on it from my bread this morning.
This is a tissue, though. It's a tissue roll.
Yeah.
All right. Oops. I'm sorry. I'm getting a little slap happy with my PowerPoint here. Okay, so that was a review of what the board's actions had been before, well, as of March 27th when I did the first webinar, and here is the ongoing guidance that the board has issued since then. I have an itch on my nose and I'm trying not to touch my face. All right, so the cancellation of workers' compensation, disability, paid family leave policies, etc. The governor issued an order putting a moratorium on insurers' ability to be able to cancel insurance policies for 60 days. and when was that? I think that was, I want to say like March 23rd or something like that. So that is coming up on expiration, that executive order, but I find it likely with that the governor will extend that order, just as he did with the moratorium on evictions for both commercial and residential leases. The formulary deadline for prescription renewals was extended. This was, just bear with me for a minute. Healthcare providers had to obtain prior authorization for a renewal of a non-formulary prescription. It was supposed to be as of June 5th, but that's now been extended to January 1st of 2021. So big extension granted there. Oh, I didn't get my cube flip there. Oh, because I went backwards. Bear with me. There's the cube. All right. Submitting prior authorization request to carriers designated email contact. So we all know that everybody's required to have a designated contact for the submission of C4 auths and MGs. That's supposed to be provided to the board. If a provider doesn't send the request for treatment to that designated contact, then the board will issue an order of the chair or a proposed decision finding in your favor, essentially, because they'll tell the doctor's office that they didn't submit the request properly. Healthcare providers were, on an emergent basis, advised to submit their prior authorization request for medical treatment to your designated email contact, as opposed on the board's website, and not by fax. I believe that this is because doctors' offices rely so heavily on fax machines, this incredibly outdated technology, that even though it still exists, you could do it completely digitally like an email, but many doctors' offices don't. And so as a result, to protect people both in carriers and payers' offices, as well as in the doctor's offices, the board changed the procedure for submission of those requests to email. The board also made some changes to the submission of medical reports and attached reports, and eased up on those requirements a little bit. If they're already in eCase, then that you only have to submit your C8.1 referencing the treatment already. You can submit bills separately from your C8.1s if the medical narrative or report isn't already in eCase. And then, interestingly, the board provided a technology solution for being able to submit a medical bill to the board using a photograph. So if you, in fact, James turned me on to this fantastic PDF converter using a photograph on my phone the other day. But the board recommends a specific application, this Genius Scan. It has it for both iOS and for Android, because I guess that the size of the file that it creates in creating a PDF from a photograph of a medical bill is a lot smaller than simply taking a photo of the report. The board also issued a new injury code for those FROIs. It's basically a COVID-19 code. So, if the writing wasn't on the wall from the letter from the chair about compensability of COVID-19 claims, then it's certainly on a sticky note on the wall with the inclusion of an injury code for COVID-19 for your FROIs and SROIs. Okay, and just to let you know that the board has issued a nice summary page of all of the guidance that it's issued in connection with COVID-19 in a single page. And again, if anybody hasn't already seen this because you're not signed up for the board's notifications, or you don't frequently visit the website, then feel free to email me after the presentation, and I'd be happy to provide you with a copy of the presentation, and you can access this information yourself. Okay, I need to go back to my presentation. All right. Now, I just wanted to return to some of the litigation issues that we've encountered in defending your claims at the Workers' Compensation Board, and to revisit the labor market attachment issue and just talk a little bit about IMEs. And so we know that the labor market attachment, that proof requirement has been suspended, all right? And these criteria that I'm listing for you here are, this is a revisit from my last presentation. It gives you details about the board's rationale for why they're suspending labor market attachment proofs. And I think that these dates are important because basically the board has said that they're not requiring injured workers to produce evidence because of the emergency that was declared. That emergency was declared on March 7th. And so I think that that's an important date for the before times versus where we are now with respect to whether or not labor market attachment may still be a viable defense. So we're going to take a look at some board panel decisions in a minute that bear that out. All right, so we know that labor market attachment must be addressed by the board before an injured worker is classified. And so therefore, if you have an individual who's ready to be classified, you'd like to get your caps in place, unfortunately, you're not going to be able to do it right now because the board is still insisting that labor market attachment be litigated as required in the statute before the injured worker is classified or the loss of wage earning capacity is determined. So one of the questions that arises is how do you take advantage of being able to run your caps when we cannot have litigation proceed on your loss of wage earning capacity? One of the things that we might want to consider when we're handling your claims for you at the board is requesting a finding that if all the doctors agree that the claimant is at MMI as of a certain date, and the only thing that we have to determine is loss of wage earning capacity, which we can't do because the board is holding labor market attachment in abeyance until the economic crisis has resolved, then my recommendation would be that we request that the claimant be classified as of that date and that the caps start running with a determination as to whether or not benefits will be due because the claimant is attached to the labor market ultimately or because they will not be due. It remains to be seen whether or not the board would agree with that kind of an argument, because certainly one of the things that an individual could do when they when this epidemic or pandemic is over is that they could get a job. And if they get a job, then the board treats that as the caps don't run if you're earning in excess of your established average weekly wage. So I think if we took a reasonable position, which was that caps should start running as of the date that we are unable to litigate labor market attachment, with the exception that if the claimant ultimately returns to work earning in excess of their average weekly wage, that the period would be not counted against their caps, I think we might get traction with that. In connection with today's webinar, I did go ahead and look to see whether or not there were any board panel decisions that had been rendered since March 7th, and lo and behold, there have been. So I found 7 cases that referenced COVID-19, the earliest of which I think was in April of some time. What I want to look at first with those board panel decisions are 3 decisions that addressed labor market attachment: Republic Services, BJ's, and Chipotle. Republic Services of New York, which I've given you the board number and the date that it was decided, this is a situation where I'm sure you all have experienced a similar fact pattern, and we've had tons of these at the board, where claimant was previously directed to produce labor market attachment proofs. And in the interim between when they were directed to produce labor market attachment proofs and when the case came back on the calendar, we had the epidemic, we had the pandemic. So the position we've always taken is that if the claimant's proofs failed before the board relieved them of the obligation to produce evidence of a work search, that the board should find the person unattached to the labor market. And James has a great, I think, position with respect to whether or not somebody who's out of the labor market as they approach the pandemic should be entitled to benefits. And I'll let him tell you that.
Yeah, I mean, our position is that if the napkin that the board issued, that letter about labor market attachment, says basically we cannot expect a claimant to have any reasonable expectation to attach due to the economic disruption caused by the pause, then I think it's entirely reasonable to argue that they can't use that as a sword and a shield. If you can't be, if it's accepted that you can't be reasonably attached to the labor market if you are voluntarily withdrawn going into this pandemic, the same analysis would be true of your efforts to reattach. The carrier has no expectation, or the employer has no expectation, that the efforts that the claimant undertook could be deemed genuine or actually accomplish what the whole premise of the exercise is, which is to find suitable replacement employment. So how can you remain attached to a labor market that is so badly shaken that you don't have to continue to look for a labor market or look for work when you were attached? How can you possibly reattach under the same circumstances? I had a judge yesterday, I made this argument yesterday. The judge said, well, it sounds like you're using it as a sword and the shield. And I said, actually, Your Honor, I think you're misusing that, that phrase, because the claimant's bar is trying to use it as both a sword and a shield. The claimant can't have it his own way.
And James, I think this decision will probably make your head explode, because what happened was, after the hearing, the claimant produced labor market attachment proofs on March 11th. Okay, so the hearing was in February at some time. After that hearing, and after a judge made a decision, the carrier raised the issue of labor market attachment before, so it was a February decision, so the appeal was in March. So it was before the epidemic or any of these guidelines from the board were issued. So the judge had refused to suspend, despite the fact that the claimant had failed to produce any labor market attachment proofs. After that hearing, the claimant produced labor market attachment proofs on March 11th, and the board found that the claimant was entitled to benefits as of March 11th, but the labor market, they rescinded awards before March 11th because the claimant hadn't produced any proofs. But as of March 11th, the claimant gets awards either because he produced a work search or because he didn't have to.
Wow, that violates the board's own rules about considering additional evidence, which violates at least 2 appellate division cases issued last year. And I mean, it's a due process violation as well, because the employer in this case didn't have an opportunity to check that work search out.
Yeah, it's a little crazy, the decision. I was sort of stunned by it.
I mean, this is the kind of decision that gives the board a bad name and should make people concerned about their rights.
Right, but it was a good decision from our perspective, in that the board reversed the judge's finding that because the claimant, or that they reversed the finding that the claimant was not attached to the labor market when the issue was ripe and it was, joined or justiciable, or whatever word you want to use. They found that the issue should have been considered before March 11th of 2020, and so they did rescind awards before that date.
Doesn't this, I mean, everyone that's on this call, this reeks of politics. This reeks of politics. This is not law, right? This is our state, our New York Workers' Compensation Board not wanting to be seen suspending somebody's benefits during a period of a national emergency, whether it's related to that emergency or not. It's a source of revenue, and they're treating it like a source of revenue.
Well, the only thing I will say is that the decision did allow it did reverse the judge's decision with respect to, the finding that the claimant was not attached to the labor market before March 11th. So for our perspective, we'll use it, at least to support our claims where the labor market attachment issue arose prior to the pandemic. At a minimum, to carve out those periods before the board says that somebody didn't have to produce evidence. I'm running a little bit short on time, so I'm just going to kind of run through these other decisions real quick. This BJ's Wholesale Club supports that. I think this is the one.
This was the one where they held it in abeyance, right?
Right.
They're basically, the board is basically holding labor market in abeyance.
Right. This is a problematic decision. The next one is somewhat beneficial. So we have one good, one bad, and then one that's a mixed bag. In this one, the carrier argued, following decisions in December and January, that the judge should not have held the issue of labor market attachment in abeyance, because it sounds like, as many judges are wont to do, they just continue the cases for the claimant to get an additional chance to produce their labor market attachment proofs. And the carrier appealed this. The last decision was January 28th, and so before the pandemic. And what the board did was said that they're going to hold the issue in abeyance because of the pandemic. not because, for the reasons that the judge found, but because there's no way that an individual can attach to the labor market right now. So for different reasons, the board basically affirmed that decision. And then in Chipotle, we kind of got a half win, half loss. In this one, the employer argued that the claimant should not be entitled to rely upon his alleged ongoing employment relationship with the employer as evidence of labor market attachment. So as I'm sure most of you know, an employee who continues to be an employee at the employer of record for the claim can argue that their ongoing continued employment with the employer relieves them of an obligation to seek work elsewhere. As James will tell you, that reliance has to be
reasonable. They have to have they have to have some reason to believe that they would actually return to that work.
Right. So it's not a blanket rule. So just because you're insured, or if you're self-insured, your employer has not officially terminated the claimant, that's not an automatic bar to raising labor market attachment. Their continued reliance on their employer record has to be reasonable. In this case, Chipotle, there was a question of fact as to whether the injured worker could continue to reasonably rely on his ongoing employment with the Chipotle to relieve him of the obligation to seek work within his restrictions. The board found that the employer should have been able to develop the record on that issue and to offer facts showing that the claimant had been terminated, or that it was unreasonable for the claimant to continue to rely on his his employment relationship with Chipotle to relieve him of the obligation to seek work with his restrictions. And however, so even though the board found that the employer should be permitted to develop facts on that issue, they then found that because of COVID, they're going to hold the issue in abeyance. So the employer wins, sort of, because ultimately they'll be able to go back and litigate the issue of whether or not it was reasonable for the claimant to continue to rely on that employment relationship. But in the meantime, they're going to have to continue making payment of benefits. So real quickly, the other board panel decisions that I found, the first of which just had language in it from the board, like kind of, telling everybody, can't we all just get along during COVID-19, and encouraging the parties because of the emergency situation in Palo Cambaro of New York to try and work issues out where they can. And then there were 3 decisions which permitted late filings, 2 rebuttals, 1 appeal in Church Mutual, Highgate, and Triborough Plumbing. And lastly, I just wanted to touch on getting an IME. As I mentioned already, the board's been very liberal about granting extensions. My discussion with IME companies, and they've continued to schedule IMEs with the optimistic hope that at one point we might be able to actually have an individual examined again. And I do think that IME companies will be are part of our phase 2 rollout, part of professional services. And as many of you may know, the phases that we're reopening in New York require a 2-week period in between phases to assess the data with respect to whether or not we continue to meet those 7 benchmarks to allow a region to progress to the next phase. So, for example, in what's the Syracuse area? Central New York. So Central New York region, you met your criteria yesterday, you met all 7 benchmarks yesterday, so you're allowed to reopen today, provided that the 7 criteria that the governor laid out for being able to reopen. This is how I assume it's going to work, although there hasn't been any specific guidance on whether or not this is how it's going to work with respect to the 2-week periods in between phases. As long as you don't fall or slide backwards on any of those 7 criteria, then my belief is you'd be able to transition back into phase 2 by whatever 2 weeks from today is, 14th to 29th. Yeah, that's right. So hopefully you will be able to get IMEs in within the next couple of weeks. Now, you saw the criteria that you're going to need to meet, and at least that the phase 1 employers need to meet with respect to making sure they're both their employees and the general public are safe. So you can guarantee that if a claimant, shows up at the testing or at the IME facility and somebody behind a desk isn't wearing a mask, they're going to be like, I'm out of here. All right, so it's going to be very important to for your IME vendors to be able to provide you with their safety plans once the requirements and guidance for professional services gets issued, for you to know that your IME vendors are meeting those criteria. Also, you can always continue to request record reviews. And just lastly, we talked about a couple of issues that popped up today during our scheduling meeting. And James, I just wanted to touch on those. One of the things that came up was that our attorneys are, and I would encourage you to do this also, for those cases like where you get a schedule opinion and you can't get an IME within, another 6 weeks or so. I'm looking for my notes from my meeting this morning. Then, oh, here they are. Then you could consider going to a claimant's counsel and just saying, hey, look, here's, your doctor says 55%. I can tell you that because he included additional percentages for chondromalacia or under whatever the permanency guidelines are for the particular body part, that he inflated your schedule loss of use by 10%. Let's assume that I would get an IME and there would be a proper interpretation of that. Are you willing to stipulate today to a schedule of 45% in lieu of us having to wait to get an IME? And that, claimants counsel may advise their client to do that because people are hurting for money, and they might want to stipulate to a lower schedule in lieu of having to wait for how long we don't know before we would be able to get an IME on that issue. Our attorneys were asked about IMEs, and another idea that came up during our scheduling meetings is that when permanency is at issue, especially on a classification kind of claim, claimants are frequently given multiple opportunities to produce their evidence of permanency, that we, at the time that a claimant, like at the first medical production hearing where a claimant is directed to produce their own evidence of permanency, that we ask the judge that the claimant only be given one opportunity to produce that medical evidence. And again, the reason for that is that you would want your caps to start as soon as possible, so we can at least ask for it and possibly to start the clock running on that. So that's pretty much what I wanted to touch on. James, was there anything else from our scheduling meeting that you wanted to bring up that
not specifically, but I did get a good question while the presentation was going on.
Fantastic. That brings me to my next slide.
Yeah, so I got a question asking about section 10.3b, which it's one of the more obscure provisions of the workers' compensation law, which are my favorites. And
go ahead.
It's the needle stick law. So the question was, does section 10.3b talk about or provide any traction for a claimant's attorney to say, well, I have an employee who is in one of the safety worker categories who was exposed to a bodily fluid. Does that create a presumption, since it lives under section 10, which does talk about, it's a reverse section of presumptions, like what's presumed in and what's presumed out. And so then the question that's made at that point is, does that person end up with a presumption because of their exposure to fluids? And I think my answer is going to be no. Section 10.3a basically says if you're part of a public safety worker, and then they talk about firefighters, EMTs, police, corrections, civilian employee, Department of Corrections, it basically goes on and on and on. And if in the course of performing their duties they're exposed to blood or other bodily fluids, then basically their boss can go ahead and say, please go ahead and immediately get a test for any of the loathsome diseases that you may have contracted from that exposure, and we're going to go ahead and treat it as though it's causally related, or at least in the moment it's going to be liability of the carrier. And so the question that I was asked that was really good is, doesn't section 10.3a create a presumption? And then I went in and I said, that's a really good question. So I went and looked for case law, and I did find a case that talks about this, where there was an argument about a presumption of a physical exposure as a result of the fluid. And the board came back and basically said 10.3b is only for testing payments. It doesn't stand as a substitute or any sort of presumption, because under the old section that dealt with needle sticks, blood exposure, that sort of thing. The old section basically said, if you tested negative, you had to put it under your private insurance. And they said that was a mess. So the board issued a new law, 10.3b, saying whether you test positive or not, you're covered for the testing and the prophylactic treatments that you're given until the point that you test negative. So they basically said, if you're exposed, it's a precautionary coverage. So you can have a claim for a needle stick when it's a negative. You just are liable for the bills. It probably wouldn't be established for an exposure, but the judge would come in and say, I'm going to find the bills for treatment payable under section 10.3b, but I'm otherwise disallowing the claim because there was no contracted disease. The carrier is liable for medical treatment, no further action. So I hope that answers that question. It was a really good question.
Yeah, in fact, there's not a claimant's attorney online, is there?
I don't think so.
Okay. We did have one of our attorneys, I looked at my notes again, did bring up a case today, which was a COVID-19 case, and it was accepted, but there were defenses to lost time. So just because you may find yourself constrained to accept a COVID-19 claim because you can't refute the exposure, or it's pretty clear that the individual contracted the condition in the course of their employment, you may still have defenses to lost time. So certainly feel free to run those kinds of cases by us or by your defense counsel. You know, I mean, obviously, yeah, it has to be fact specific, and each case has to be judged on its own accord.
Yeah, I had some really good questions yesterday there were some very fact specific, and I mean, we never have to prove alternative causation, but it helps if you can, right? Because the burden is substantial evidence. Judges often tell us, you know, in writing, off the record, on the record, the board never says it, but the judges will say, it's like, you know, your burden's pretty high. You can't just come in here and tell me not it, you know, like put your finger on your nose. No, we didn't do it. They want something else so that they can be convinced that there is a compelling alternative theory. And, you know, sometimes it's the tail wagging the dog, and all we've got is the claimant saying, this happened at work. But if we can come up with some other theory, you know, we can get some evidence for it, it's great. Except what I came across in discussing this with the clients yesterday was some of the ways that we go about proving it are blocked to us because we would have to be getting a hold of third-party medical records that we just simply have no right to get a hold of. You know, what if we could never know whether a spouse contracted the disease first, and then the spouse, the worker that we're dealing with, contracts it subsequently. But what if that worker also works in healthcare? They're going to say, well, I got it at work, and they may never tell us about the spouse, or they may tell us the spouse has it, but not tell us when they tested positive for it or when their symptoms manifested. So we don't know whether the spouse infected the claimant or the claimant infected the spouse from work, and there's no way to get a hold of that information, and we're stuck with.
Well, I wonder about that. I mean, I wonder whether Department of Health would have to keep, you know, records of individuals who have contracted the condition to require them to quarantine, and then whether you might be entitled to that kind of record under a, you know, FOIA or application.
Do you think the board's going to wait around long enough for us to get a FOIA response?
They actually, I mean, sometimes they're pretty quick, but right now they're probably not. You're right. I mean, it's like, who's there to do them? Yeah. So if there's nothing else and there are no other chat questions, thank you so much for tuning in. We really appreciate your interest, and stay tuned for additional webinars coming next month. We may be resuming our regular webinar series, or we may come up with a new TV theme, given that we can't have as much fun with our green screen as we used to when we had everybody in the office. But thank you again for tuning in, and please feel free to email me or James after today's webinar, and ask any questions that you might have, or if you'd like a copy of the materials. They will be available, a recorded version of today's webinar will be available on our website. And as I said a couple of times during the presentation, I'm more than happy to give you a copy of the presentation. So thanks again for tuning in, and stay safe and healthy.
Bye, guys.
Bye.